Hi, you probably wondered why a video on Qui Tam federal false claim law starts with a beautiful view of the ocean that you just saw, the shoreline. And the reason I did that is I thought if you look closely, you might see some hidden rocks popping slightly above the surface with many other rocks below the surface. Kind of like it is in Qui Tam law. We really don't know sometimes until we hit the rocks what those rocks are and how they could effectively prevent your claim from leading to a recovery. And so part of what we like to do is to study ahead the chart that our Qui Tam boat will be going over in terms of the water, try to find those hidden perils before we actually get to them. Now, with that said, let's move on to defendants and the Qui Tam law. Hi, I'm Steve Danz. Thank you for visiting our Federal False Claims website. Today I wanted to chat with you about who is the actual defendant in a Qui Tam or false claim lawsuit. Different circuits around the United States. Here in California, we of course are in the Ninth Circuit, but each circuit has a little different test as to how carefully a defendant must be identified. Now, in the healthcare field, and by the way, 77% nationally, according to the last studies, have shown healthcare to be that percentage of all federal false claims submitted. It's common to allege a common scheme among a number of different defendants. Could be pharmaceuticals, billing agencies, hospitals, things of that nature. Generally speaking, the courts have made a chain and daisy wheel comparison regarding naming an individual defendant, rather than putting an entire industry together and saying all 20 hospitals or healthcare providers or radiological services, whatever, engaged in the scheme. And so under the daisy chain or the chain technique, it's important that the Qui Tam realtor identify the name of each defendant in the chain, because without their particular participation, the chain would be broken. So here we would want to name an individual defendant. However, let's look at the hub and wheel conspiracy. Under that analysis, if you put the defendant in the center of the hub and the wheel as the hub, then it's not necessary to identify each and every defendant on the edge of the wheel, because the scheme is complete as to whether or not it was to even one particular conspirator. So it's always better to name all, but under the Ninth Circuit allegation of chain versus wheel, it may not be critical. So a lot of times a relator will come to us and say, I have general knowledge of the scheme. I was out making sales calls, calling on doctors, whatever, and I don't know the names of any actual claims. There has been a sea change over the last 20 years in false claims to where now a description of the scheme with some particularity may replace actually having proof of any particular false claim, because even though the relator or the employee may know about the scheme and have it described to them and told to get certain information or bill in a certain way, doesn't mean they're going to have actual copies of the claims. So as long as the relator can avoid coming to us or any of the other excellent Qui Tam law firms out there, based purely on speculation, estimates, and what sometimes is called logical conclusions, there's probably going to be enough interest to get a Qui Tam case, at least to survive a motion to dismiss. The Ninth Circuit has gone one step further and has actually said, unlike most federal court pleading, which must be specific as to time, date, and place, that pleading on information and belief is sufficient in many cases where the relator can prove or allege with some particularity why they believe the scheme is in existence, how the scheme works, the time periods it covered, and things of that nature. So a very complicated area of law, but if you're still employed, and by the way, most cases do come from ex-employees. I think the last statistic showed about 65% of all Qui Tam cases came from former employees. But it's good to be able to trace the actual information while you're still employed, never taking actual documents, but for example, being able to tell your attorneys the date, time, and place of any documents you have seen. So keeping an outside log allows the government, should they intervene, to get exact copies of those documents. Brief overview of some of the more inner baseball workings of federal false claims. Would love to chat with you about your case. If we can't help you, we'll try to find you someone who can. Thank you so much. Steve Danz Associates.